A power of attorney gives an agent the authority to act on a principal's behalf. It may be broad or narrow depending on its intended purpose. The Vermont Supreme Court considered a power of attorney's scope in Estate of Kurrelmeyer. Louis Kurrelmeyer executed his will in 1980. The will specifically provided that Louis's wife Martina would take a life estate and property Louis owned, referred to as the Clearwater property. After Martina's death, the Clearwater property would pass to Louis's children. In 1996, Louis, while still competent, executed a durable general power of attorney appointing Martina as his agent. The power specified that it would survive Louis's subsequent disability or incompetence. And the power authorized Martina to act in Louis's name in any way that he could himself, to the extent permitted by law. Among other broad powers, Martina was specifically permitted to add Louis's assets to any trust of which he was the donor, as well as to execute trust instruments. In 2000, Louis had become incompetent. Martina established a revocable living trust with herself as co-trustee and transferred the Clearwater property to the trust. The trust gave Martina greater rights in the Clearwater property than she would have had under the will, including the right to sell it. Louis died a year later, and Martina was appointed executor of his will. When Martina prepared an inventory of Louis's estate for probate, she left out the Clearwater property, which was no longer part of the estate because it had been transferred to the trust. Louis's son, Louis Kurrelmeyer Jr., asked the probate court to set aside the trust, arguing that Martina had exceeded her authority under the power of attorney by creating it. Louis Jr. asked the court to include the Clearwater property in the estate to be distributed according to the will. The probate court upheld the trust. Louis Jr. appealed to the Superior Court. The Superior Court granted summary judgment for Louis Jr. Martina appealed to the Vermont Supreme Court.